everyone, my name's Stephanie Brown and I'm an associate.
Hi everyone, my name's Zoe Adams and I'm an associate, and Stephanie and I work together at Michael Lynch Family Lawyers. Today we've been asked to discuss with everyone spousal maintenance, and one of the important parts of spousal maintenance discussions needs to be in respect of who is eligible to make a claim, because in terms of a lot of other information out there, Stephanie and I were discussing that it seems to imply that there's almost an automatic right of entitlement at the time of separation following the breakdown of a relationship, whether that be a marriage or a de facto relationship. And I think it's just really important to clarify at the outset that it's not going to apply to everyone's relationship, and Stephanie's just going to talk to us a little bit more as to when you may be eligible to make an application for spousal maintenance.
Yeah, that's right. So it's not automatic, and people do come in having had different discussions and done Googling online to find information, and that can make discussions with clients really difficult sometimes because they may have the wrong information. So I think it's important to come in and give a good solicitor the information so that you can get advice. So essentially it means that you can't meet your financial needs from your own kind of sources.
Yes.
So if you have a low income or you're not working, and there may be a reason for that, so care of children, you may be unwell, you may be unable to work, dependents, or there may be some retraining that you're doing to be able to be employed in the future. So that kind of thing comes into account so that the court looks at, is there a need to meet that from the ex-partner's income, basically.
That's right. And again, in terms of that discussion, it's often both parties. So sometimes it is in respect of not only the person who comes into us is the person who's in that financial need, but it can also be the other person who's been asked to assist with the other's financial support, and they want to have an understanding exactly in relation to what level of obligation they have and how long that may apply for.
Yeah, that's right. And it is a separate obligation as well to something like child support. So that's something that people often, there's a formula assessment for child support, and that is a separate issue. It's also separate to your property settlement entitlements. So a property settlement is obviously where you're dividing the assets at the end of a relationship, but that's a separate claim to your spousal maintenance claim.
That's right. And again, just further on that point that Stephanie was making in relation to the formula assessment, it really is a particular calculation in respect of the two parties to the relationship, and also what's being considered a reasonable standard of living throughout the relationship as well, and the extent to which that can continue.
Yeah, that's right. So the court's going to look at the person that's in need and their income, their reasonable weekly expenses, and that sometimes does look at things like what was their standard of living when they were in the relationship with the person, and that obviously differs from case to case. So if they have an income and their reasonable weekly needs are falling short of that, and then if the other party, based on their weekly income and their reasonable weekly expenses, do they actually have a capacity to meet some of that shortfall?
Yeah, that's right. And again, whilst it's important to be having these discussions as early as possible following separation and trying to negotiate and reach an agreement between yourselves directly as to what that financial support will look like, it's also important to bear in mind that there are some time limitations that are relevant to a spousal maintenance claim or a maintenance claim in respect of de facto relationships. So in respect of de facto relationships and maintenance claims that may arise, it is the time limitation is 2 years from the date of separation or when the relationship breaks down. And Steph, in respect of marriages?
Yeah, so for a marriage, it's after the application for divorce. So once the divorce has been made final, which is a different date to your application, it's a different date to the hearing date of your divorce, it'll be on your divorce certificate. 12 months from the date of that final divorce is when you've gotten to make that application to the court. So definitely important in both cases, whether it's de facto or marriage, to get legal advice well before either of those time limits has expired.
Exactly. And I think Steph's just got something that she can show to you in regards to a fact sheet that we have available online. And there's some other resources that are also on our website, such as articles that you can certainly have a look at. But if you do think that this applies to you and you need to get that specific advice, come in and make an appointment and see one of the lawyers here.
All right, thanks, Zoe.